Mr. Russell, over to you, please.
Ipsos Custodes thanks the court for this opportunity to intervene on this issue. Ipsos Custodes possesses specialist knowledge and experience in nuclear engineering, and health physics, and is ardently pro-nuclear. The proponent has brought forward a fine example of a near-surface storage facility. If it was licensed as a storage facility, Ipsos Custodes would be sitting before you and supporting a storage facility as proposed, but it is not proposed as a storage facility. It is proposed as a disposal facility. The NSDF, however, in its present as described form, might be a reasonable decision as presented, but is certainly not a correct one, at least in my opinion as presented. And an opinion of Ipsos Custodes, rather, for the record. The Ipsos Custodes brings forward the case that the honor of the crown cannot be considered satisfied because the court has failed to inform itself of the impact the project will have on Indians' rights and communicate that impact to the Indians. Furthermore, it has failed to consult with non-status Indians. It is settled law in Canada that non-status Indians are Indians, the Daniels decision. And for the purposes of consultation, the Daniels decision also says, Her Majesty has made no effort to date to consult with non-status Indians to date on this issue. The court has failed to properly interrogate the post-closure peak dose to the public. No probabilistic safety assessment has been performed on the NSDS failure outcomes. Therefore, as an aphorism goes, since what can be asserted without evidence can also be dismissed without evidence, the court must dismiss the assertions that any particular failure mode is any more likely than the other, except for the probabilistic ones, maybe earthquakes, say. I'm not considering those at all. The peak dose, however, is found in the safety case called HI, Hotel India, well case, shallow contaminated well, end quote. This particular case is the peak dose to the public as found as someone drinking and using the contaminated well, if they were living on the NSDF post-closure. The CNSC staff are well aware of this outcome because they required the proponent to limit contents of the NSDF so that the predicted dose would not exceed 1 millisievert through this outcome. 1 millisievert per year, for the record. This must be considered the bounding case of the facility now, because this is the peak dose to the public. This 1 millisievert quantity is over 3 times higher than the stated design criterion of 0.3 millisieverts per year. Since the committed effective dose to receptors is significantly impacted by the surface water velocity and soil porosity, Ipsos Custodes requests and has requested the information and the computer codes to recreate, confirm, and comment on this prior to the license being granted. This request is framed as an Indian requesting this information so that this Indian may exercise his constitutional right to comment on the administrative decisions that affect said Indian. Without this information, the consultation will be incomplete and the honor and the crown unsatisfied. On a technical basis, Ipsos Custodes requests that these values not be less than those used to calculate the unconditional clearance levels, a value the court has already based in its regulations and other decisions. A fundamental failure that prevents this facility being used for disposal is the generational iniquity that the design proposes. Today, if I or you want to dispose of radioactive material, except for a few special cases, the radioactive material would have to be below either an unconditional clearance level, a conditional clearance level, or an exemption quantity. All these values are based based on exposing the public to not more than 10 microsievert per year dose. Even if the design criterion was met, that would still expose the public to 30 times the currently acceptable value for disposal of radioactive waste. Since the proponent proposing exposing the public up to this 100 times, as we see in the 1 millisievert case, it is prima facie unethical to burden future generations with a higher radiation dose than the one making these decisions, the generation making these decisions. Decisions based on the honor of the crown must be made on the basis of correctness rather than reasonability, because it is a constitutional duty. The court is barred from simply making a reasonable decision on NSDF. The court must make a correct decision. It must be held to the higher standard of the correctness. And Ipsos Custodes believes that the correct decision is to license this facility as storage only. My ancestors lived on the very site where the proponent seeks to build the NSDF. On behalf of all our ancestors and all our children, Ipsos Custodes seeks consultation and accommodation so that our future generations will not have to be exposed to more radiation as a result of human activity than any person alive today in Canada, whether they live on the NSDF or not. Ipsos Custodes thanks the courts for this consideration.
Thank you very much, Mr. Russell, for your presentation. Ms. Maharaj.
Can I just have a moment to gather my thoughts?
Of course, we'll move to Dr. Lacroix.
Thank you for your presentation. Could you tell us more about Ipsos Custodes? What is this organization? How many people? And why this name?
Thank you, Curtis Russell, for the record. Ipsos Custodes is a licensed business in the province of Ontario. Our business is the betterment of society and as a whole. And Ipsos Custodes, the name, comes from one of Virgil's poems, roughly to translate, "Who watches the watchers?" Thank you.
How many members?
It is a business, a sole proprietorship. Thank you.
So maybe I'll ask staff the question on the safety case. And the comment first made that there has been no PSA done and different failure analysis, but is specifically what's in the written submission around a scenario that has been assessed that actually results in a peak dose higher than what has been established as an acceptable dose. I think it was 1 millisievert per year. Can you shed some more light on that, please?
Yeah, so thank you, Kavita Murthy, for the record. So according to the radiation protection regulations, the dose limit for members of the public for doses from plant exposures is 1 millisievert per year. This is in line with the IAEA requirements. In this case, for a normal evolution scenario of the NSDF, which basically does not take into consideration disruptive scenarios, a dose criterion of 0.3 millisieverts has been established. And this is again consistent with our regulatory documents and IAEA requirements. What the intervener has brought up is a human intrusion scenario, which is considered above and beyond a normal evolution scenario. And for those situations, both the IAEA documents as well as CNSC documents say that the expected dose, if human intrusion should not lead to a possible dose of more than 1 millisievert. So the 1 millisievert is the criterion that has been used for human intrusion scenarios. If you need more detail, I can have Dr. Herod speak to it.
So the shallow contaminated well would be a human intrusion scenario?
Correct.
Okay. And the intervener is also formally requesting all information and models on, I don't know whether it's just on this particular evolution or other scenarios that have been assessed. Is this publicly available?
So Kavita Murthy, for the record, so these would be models that CNL has used, so I can ask CNL.
Thank you. CNL?
Megan Vickert for the record. So before I talk about the models requested, I just want to note that with the human intrusion scenario, we did use that in our iterative process for the waste acceptance criteria to inform lowering a couple of the radionuclides to ensure that would not happen as well. So it's part of that iterative process in developing the waste acceptance criteria. With respect to the models requested, CNL did utilize AMBER model, which is available within the industry, but you do have to have a license and specifically qualified and trained to utilize it. So our input and output files were not provided when requested, but we did provide a copy of the post-closure safety assessment, which is transparent in providing the extent of models and data should an intervener want to repeat the analysis on their own with a model that's available to them. I just do want to comment, not to send it back to CNSC staff, we did submit our input and output files for the AMBER modeling so that CNSC staff could review and confirm. CNL also did their own validation that the outcomes of AMBER did make sense by utilizing a different model, ResRad, which doesn't necessarily have the same delineation for this type of facility.
And is this particular HI well case the bounding case for your safety case? Sorry, in your safety case?
Megan Ficker, for the record, yes, I guess you could qualify it. It is a what if scenario because it is a human intrusion. So it would be, there's a number of inadvertent intrusions, including the well scenario, but we also have a mass excavation. And now that we've lowered, there were nuclides from the results and recommendations of that analysis, we're now within all the limits that the CNC staff have identified.
Thank you. Ms. Maharaj?
Thank you, Madam Velshi. In your intervention at the beginning, you said that if this facility was being requested to be permitted as a near surface storage facility, you would support it. But because it's a disposal facility, you don't. Could you clarify that for me, please? What are the criteria where you find discrepancy in your opinion?
Yes, Curtis Russell for the record. The institutional controls are believed by associates to be perfectly adequate. The issue comes when an institutional closure ends, and we have to assume after 300 years it does so, that the worst, I shouldn't say worst case, but a reasonable case where the surface water is being used for human life on the NSDF after 300 years, the dose there would not be in keeping with the dose to the public that we would allow the public to receive today. And so it fundamentally comes down to the release in the surface water of the radionuclides, particular iodine 129, that those receptors would receive. And so it's actually the disposal is the issue because it's the controls are believed to be adequate.
So your position is that if this was a storage facility, that it would not go into institutional control and would not be released from institutional control? Is that what you're saying?
Well, storage implies retrieval. Okay, so a storage license always has to assume retrieval. And the proponent has made several of these mounds already that are licensed as storage facilities. And so if this was also a storage facility, it would be perfectly acceptable because of the institutional controls.
Well, you just said that the institutional controls and then the termination of institutional control was the reason that you didn't agree that it should be permitted as a disposal facility or is acceptable to you as a disposal facility. So I think I'm confused by your position.
Yeah, I'm confused too. So the after 300 years, institutional controls end. In a storage facility, that won't be the case.
Okay.
Because it implies retrieval.
So then, as long as the materials are able to be retrieved but remain in place, you're okay with the proposal. But if they are not planned to be retrieved but remain in place, right, you're not okay with the proposal.
Right. The abandonment is the issue. The license to abandon would be the issue. Final abandonment.
Okay, well, that's a new concept because what you talked about before was dosing if there was to be a person who utilized the surface water on the surface of the mound
Right.
at the point of completion of institutional control.
No, not necessarily at the HI, say the human intervention timeline. So when they're assuming after some point in time, there'll be free reign. Society's collapsed 300 years in the future. So you can't assume that somebody won't come and make a well right there.
But if society collapses 300 years from now, how will the storage be different from disposal? Because with disposal, the wastes are capped and planned to be interred for the rest of time. Whereas with storage, that assumption isn't true. So if society has collapsed, you're in a higher risk situation in a storage scenario.
Not necessarily, because you wouldn't be necessarily leaving it for 300 years in storage.
But if you were, because there's no requirement that storage be retrieved within a time frame. You haven't stated that. So I'm missing your point.
I'm saying that the final disposal characteristics, as it's designed to do, the thing is the design, right? So if it's not designed to be, then as a storage facility, then it's, or if it's not designed as a disposal facility, then it's not a disposal facility. And so the case is you have to interrogate the final consequences as part of your licensing basis.
Okay. Okay. Thank you.
Mr. Russell, I'm not sure if you were here earlier when Mr. Elder walked us through the different stages or the different phases of this facility. Mr. Elder, this may be worthwhile just talking about wants to move out of institutional control. The proponent would still have to demonstrate that it is safe to do so. And even if there was intrusion, there wouldn't be a problem. There's still kind of a safety case to demonstrate that you just don't abandon. There's no such thing as abandonment for the disposal facilities. But Mr. Elder, over to you, please.
Yeah, Peter Elder for the record. So as I mentioned, when we do at each phase of the facility, so right now we're talking about construction. As you go through the phases, so at closure, you would redo the safety case. And right now, because obviously we're looking fairly far into the future, it's a bounding case. So at closure, you would redo it. Post-closure, before any decision to leave institutional control, you would redo that safety case. So what we have right now is a bounding estimate of what the doses could be at the 300-year mark. The expectation is as you get real data, so we're talked about the waste acceptance criteria, there will be actually measurements of the radioactivity that's placed in the mound. You would actually have performance data of how the mound and estimates of the mound are behaving. Then you would be able to update that safety analysis, and the expectation would be that those doses would be much lower. But that is something, and that would have to be evidence, would have to be presented to the regulatory body at the time before you moved into another phase.
Thank you. I hope that helps, Mr. Russell, that you could then not worry about surface water if it's no longer under institutional control. No. Okay, well. Thank you for your intervention and expressing your concerns. Anything else you want to add before we move to our next presentation?
Curtis Russell for the record. No, thank you for your time, and thank you for giving me the opportunity to speak to the court. Thank you.
Thank you.